Good morning, everyone. Welcome to our Consumer Issues program at Cornell Cooperative Extension. I'm Mike Danaher, an Assistant Attorney General with the New York State Attorney General's Office. My office is out of Binghamton, and Binghamton includes in our region the Ithaca area. We've been doing this for a really long time, and I appreciate Cornell Cooperative Extension's hospitality in hosting these particular sessions. Today's topic is one that it's that time of year. It's when home improvement contractors start getting into season, start doing their work, and we have to follow up with our long-time adage, which is we need to be good consumers when we're considering undertaking a home improvement project. These can be very expensive to do, and it involves undoubtedly our most expensive asset or thing that we acquire throughout our lives, which is our homes. So I'd like to give a few tips about what to look out for, what to do to protect yourself, so that you understand going into a home improvement contract ways that you can go about protecting yourself. We actually have laws in New York State that deal with home improvement contracts, and it foists upon the contractor the obligation to meet certain requirements. And so you as consumers should know that, so that when you are undertaking one of these jobs, you'll know what to do, what to expect when it's time to have the work done. So we have this thing called the Home Improvement Contract Law, which is contained in the New York State's General Business Law. And it covers all types of home improvement work. In fact, the definition involves repairing, remodeling, altering, converting of residential property, and includes but is not limited to construction, erection, replacement, or improvement of driveways, swimming pools, siding, insulation, roofing, windows, terraces, patios, landscaping, fences, porches, garages, solar energy systems, flooring, basements, other improvements of residential property, and all the structures or land adjacent to it. So you can imagine it's a really large definition. It does not include the construction of homes or new construction. However, it does include a custom home. So a custom home is actually a new home that's built on land owned by the homeowner at the time they entered into the contract. So it wouldn't apply to what a lot of people refer to as a spec home. So if you go to other property that's owned by someone else or owned by the contractor, him or herself, and they had built a house on that property brand new, nobody's lived in it, but if you go to them to buy that house, that doesn't fall within the category of a home improvement. But if you own land and you hire a contractor to put a home on that property, it would include that custom home. So it includes everything: driveways, landscaping, swimming pools that you put in. All those things constitute home improvement. Therefore, they fall within the home improvement law and imposes upon the home improvement contractor certain obligations. First thing is, a lot of people don't realize this, is that all home improvement contracts must be in writing. Now, a home improvement contract imposes that obligation on a home improvement contractor. How do you become a home improvement contractor? It's a really low threshold. A home improvement contractor is someone who undertakes all jobs, the total price of all the jobs over the course of a year is $1,500 or more. So really, in this day and age, it's one project pretty much that would then make that person fall within the category of a home improvement contract. It covers all work done by a contractor in excess of $500. And then again, there aren't too many things that aren't more than $500 now. But if it was something less than $500, it wouldn't fall within the scope of the law. It does not include cosmetics like draperies and carpets and that sort of thing. or appliances. So the installation of an appliance, it wouldn't apply. A lot of times those appliances have their own warranties attached, but it takes it outside the scope of the home improvement contract. But it is the law. It requires the home improvement contractor to provide in writing to the homeowner a written contract prior to the time that the work is done. And if they violate any provisions of that law, the fines can be quite extensive and expensive, and we'll go into those a little bit later. But in the grand scheme of things, it just makes good common sense. And this isn't just from the homeowner's perspective. It's also from the home improvement contractor's perspective. It just makes good business sense to whatever you do to make sure that it's done in writing. I'll give you an example. We recently had a complaint that came in from a homeowner, and when the complaints initially come into our office, we obviously only hear one side. So I'm reading the complaint and say, wow, that sounds pretty bad. There was all this damage to floor joists and damage to other rooms and all kinds of stuff. And I'm like, wow, this is really bad. And we sent it to the contractor, and we got a response back from the contractor. And the contractor said, I understand all these things that the homeowner claims that we caused damage to, but we didn't even touch those areas. Here's a copy of our contract. This is the only things that we did. And in essence, what they did was that they remodeled the bathroom. And so the contractor responded saying, I don't know all this other damage to the house. I mean, I don't know damage to the floor joists and things. We didn't do that sort of thing. So it really helps that everything that was to be done was in a written contract, so that there can't be any dispute later on that if there's problems that was somewhere else in the house or a scope of work that was not included in this particular contract, it can all be written down so that everybody sees what the contractor's responsibilities are and what it is that he or she was going to do. So it makes really good business sense, and it protects not only the homeowner but also the contractor. If you ever have a dispute over the scope of the work, it's very easy to be able to resolve it by saying, well, here's our written contract. This is what I was supposed to do. And in fact, I did that. I wasn't supposed to do this other thing that you say that you want done now. If I were hired to do that, we would put it in the written contract and arrive at an agreed price, and then we could go ahead and do it. This also encompasses any change orders. So you get started on a job, there always seems to be something more, or that there's something that the homeowner says, well, you know, now that we've got this wall ripped out, how about if we do this or that, the other thing? That's great, as long as the parties can come to an agreement on what's going to be done. And if there's any additional cost associated with it, it can be in the change order so that the homeowner knows, yeah, we can do that, but it's going to cost an extra $500. And they've written it down. The worst thing that happened is, and this is the scenario, wall's ripped out, homeowner comes in and says, you know, I'd like to do this, this, or this to understand, and the contractor says, yeah, you know, we can do that. And that's it. So they go ahead and they do it, and then all of a sudden at the end, the contractor provides a bill for the extra work, and the homeowner goes, whoa, 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 wait a second. I didn't know anything about that. And the contractor then says, well, I wasn't going to do it for free. And then the homeowner says, well, if I knew it was going to be that much money, I would have never had you do it. All can be resolved. Written change order, put down what it is that it's going to be changed, only takes a couple of minutes, and put down a price. And that way, both parties know. And it's at that point, before the work is done, that the homeowner can say, whoa, 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 I didn't realize it was going to be another $500. If that's the case, I don't want to do anything extra. Then great. Nobody is worse for wear because of it. So it protects everybody, get everything in writing, even any modifications or changes to it. What does the contract law require? Contract law requires the name, address, and telephone number of the contractor. So contractors, you have to make sure, even if you use that blanket form that you can get in triplicate at a supply store, make sure you write your name, address, and telephone number at the top. It really would behoove everyone, if you have a post office box, to include both the physical address and the post office address on the contract, as well as the telephone number. It has to include the dates when the work will be started and the dates when it will be substantially completed. Can't tell you the number of times I've had complaints come into our office where it doesn't have a start date or completion date, and the contractor said, yeah, well, I was doing this job on the side compared to other work that I was doing, and the landowner knew that I was going to be doing it on weekends or at nights, and I wasn't going to be able to start right away because of this job or that. It's required to be in the contract. So put it in the contract. So if you estimate it's going to be 4 weeks out before you can do the work, you put it down on the contract so that everybody knows. Also, you have to have a good estimate as to when it's going to be completed, and put in when it's going to be substantially done. You put it down on the contract. Understand that there could be potentially extension periods, why there may be extensions that are needed, but you should put those contingencies in the contract. If it's weather, or if it's you've ordered the materials, or you're going to order the materials and you aren't sure when it's going to come in, you should put that in the contract to say what may cause those particular delays. Obviously, you want to put in there a description of work that is going to be done and the materials that are going to be provided. And that can be general as far as, not every nail or board or anything like that, but especially if there's any special items that are going to be included, you have to make sure that those are in there as well. You must also give a notice to the homeowner of a possible lien law, mechanics lien that you might file if the landowner does not pay you on time. You have to put that notice in, or you're in violation of the lien, the contract law, and it could impair your ability later on. So you need to make sure that you put in a notice that if you're not paid, that mechanics lien will be filed and that sort of thing. If this is a kind of job that's going to go on for a period of time, in other words, that it's going to be that there are going to be periodic payments over the course of the contract, a certain percentage done at certain completion points along the way, you must include the draw schedule. How much needs to be completed and what payments are to be made. For example, it might be something like 10% down, and then another 20% when it's 40% completed, and then another 20% when it's 60% completed. However it's set up, the draw schedule should be included in the contract. Now, this is where we have to give a warning to the homeowners. Homeowners, be very careful about large upfront payments. Most reputable contractors have some leeway with their suppliers where they don't have to pay for 30 days or whatever when it's purchased. So they don't necessarily need all the money up front. You need to be very wary of the case where somebody says, yeah, I'm going to do this $10,000 job for you, and I'll start next week, but I need the $10,000 now. Labor doesn't have to be paid right away. Materials usually don't have to be paid right away. Be very, very careful about full upfront payments. I have my own particular adage, which is the larger the amount of money, larger percentage of the job that has to be paid up front is in inverse proportion with the contractor's motivation to finish the job. So if you pay 100% up front, the contractor has all their money. So if that carrot is always out there to where if I get this much completed, I'll be able to get my next draw, there's more motivation and incentive along the way. And it behooves the homeowner to make sure that they don't have more invested in the job than what is being completed. And so be very careful when you're discussing draw schedules or discussing any payment up front to make sure that that you are being reasonable as far as being at least not ahead of the job. Additionally, this is also a must, and it is a protection for business, the home improvement contractor as well. You must include in the contract a 3 business day right to cancel. It must be included, and because it must be included, the contractor, you need to know that if you do not include it, that homeowner's rights to cancel never extinguishes. So in essence, the job could be completed, and if you didn't give the homeowner a notice of right to cancel, they can cancel the job after you finished it. And then it's going to be on the contractor to have to go to court to sue the homeowner to get the funds, potentially get the funds, to have the job corrected. So there must be a notice in the contract that the home improvement contractor has 3 business, or the homeowner has 3 business days to cancel the transaction. Now that applies except in the case of an emergency. That's the only circumstance where the 3 days can be canceled, and the emergency has to be a legitimate emergency, and the emergency has to be documented in the homeowner's own handwriting of the nature of the emergency and waiving the 3 business days. So how does that work out? That works out in the classic situation where somebody's furnace goes on January 1st, and they just can't wait the 3 days to get a new furnace in. So what has to happen is the homeowner has to write on the contract, I am willing to waive the 3 business days to cancel because it's January 1st and I need a new furnace immediately. I acknowledge my right to cancel, but waive it and sign it. That way, there is protection. Again, it can only be in the case of a legitimate emergency. It can't just be willy-nilly wavered by a homeowner. There have been circumstances where crafty home improvement contractors have gone to the homeowner and says, look, we're in the neighborhood today and I have an extra load of blacktop on the back of my truck. It looks like your driveway needs to be fixed. Be glad to fix it for you. But you know, we're only going to be here today. So we want to waive the 3-day business right to cancel, and you can do that by just signing here. One, that's not a legitimate emergency. I've never heard of a driveway emergency. It's not a legitimate emergency. And second of all, it would have to be in writing by the homeowner acknowledging that it in fact is an emergency and put down what the emergency is. A new driveway, because it's the contractor's convenience to only be there, is not a legitimate emergency. So that must be in the contract, and the homeowner has 3 business days to cancel. That 3 business days to cancel starts upon the signing of the contract, and it is a very fast period of time. It's 72 hours, and that can go by really quickly. Many legitimate contractors will not start working on the job until the 3 business days have passed, because if they start before the end of the 3 business days and all the work that they've done, and all of a sudden the homeowner cancels within their rights to cancel within the 3 business days, then the home improvement contractor is kind of stuck. So usually they'll wait the 3 days. Plus there's usually time. The contractor may be working on another job, isn't going to get to this one right away anyway. It might be that the contractor has to get materials and things and can't get to it right away. So the 3 business days can usually pass before the work is started, but if the work is started ahead of time, the contractor runs the risk of not getting paid or having to struggle to get paid for that work. So they must be included in the contract. So these things must be included. I encourage every single item that's going to be done to be put in that contract, and if there's any other contingencies or what, detail everything in the written contract. It ends up protecting both sides. so that there comes down a dispute of something that was supposed to be done and wasn't done or whatever, both parties can pull out their copy of the contract and they can see what was actually included and what, in fact, may have been excluded. So make sure everything gets in writing so that everyone is protected. And like I said, it can be very expensive for the home improvement contractor if they do not put that written contract to the homeowner. The homeowner is not obligated by the law to have anything. It's all on the contractor. The contractor must put it in writing and provide it to the homeowner. The homeowner can sign. Fines can be up to $2,500 each violation. Even for just a technical violation, having something technically wrong and omitting something from one of the contracts can be $100 just for one of those. So it can get expensive, and so the people need to be aware that that's out there and make sure that the contract be done. Another thing that we need to point out is payments, money that's paid. Whether in deposits or anything paid in advance of work being done. So it's a different story if the work is done and then the contractor gets paid. That's simple, because then at least the homeowner knows, the work is done. But any upfront payments are particularly important that all the parties should be aware of. First of all, the law provides that any funds received for work to be performed later are dictated to be trust funds. They are to be held in trust by the home improvement contractor. And they all should be treated as if the money is the money of the homeowner. Even though the money's been handed over to the contractor and the contractor receives it and is going to do something with it later, that money remains the homeowner's money and should be treated as if it's the homeowner's money. It is not the contractor's money. Therefore, the contractor is prohibited from commingling that money or putting that money in his or her other money. So he can't deposit the money in his general business account because it's not his to do that. So the contractor, him or her, should open a separate account in a financial institution that only he or she puts deposits in. He or she does not need a separate account for every job, but all the money for all the jobs can only be put in a segregated trust account that is separate from the contractor's other basic account. The money can only be withdrawn from that trust account according to the agreed upon contract and draw schedule. Nothing more. If it's 20% after the job's half done or something, after it's documented that the job is half done, then 20% can be pulled over from the trust account over to the general account that the contractor has. So treat the money as if it's the homeowner's money until it is actually earned, meaning that materials have actually been purchased or that the job has been actually done or proportionally done. This is done to protect two people: subcontractors who do work for the general contractor, and of course the homeowner, so that the job does not get completed or that aspect of the work does not get completed, there is still that money available outside that could be used by the homeowner to finish the job. So again, any funds received in advance of substantial completion must go into escrow. The money must be deposited within 5 days of being received by the home improvement contractor, and it must be in a bank or similar institution with a branch located in New York State. it's required that it be there. Again, the property remains that of the owner, and unless in the contract, unless the home improvement contractor has already put in the contract where the money's going, within 10 days of the deposit, the contractor must furnish to the homeowner the name of the bank where those funds have been deposited. The other important thing, and sometimes home improvement contractors are artists. It's that whole finance thing that gets them messed up. You know, they're great builders and artists that can do what they do, but they're not great on the finance side. They have to be good on the finance side because they must keep a record of every deposit received from every customer. And why is that important? It's important because if the contractor does not maintain adequate records, the law presumes that the funds have been mishandled. Absent records of deposits made, the contractor is presumed to be mishandling funds. And you say, well, what happens with that? It is a crime. It is a crime to mishandle trust funds. So you may be the most honest home improvement contractor out there, but just got a little behind on the money thing and didn't keep good records. It could be a felony. So keep detailed records of all money going into that trust account and detailed records of all money coming out of the trust account and where it goes. So that when somebody approaches you to say, hey, what happened to these deposit funds that were given to you, you would have records to show. If you don't have records, you're really behind the 8 ball because you are presumed to have mishandled the funds. And unless you can prove what happened, the presumption is that you are guilty of a crime. So make sure that you keep detailed records so that that doesn't happen. Administration of that escrow account, you cannot withdraw any money in excess of the contract amount. So, contractors, be very, very careful about what funds are in that trust account and who paid them. Because although you may have, I'll just grab a number, $10,000 in the trust account, it may have been, that deposit account may have been contributed to by, let's say, 4 consumers. 4 different homeowners have paid you deposits. You put it in the account, and it's $10,000 in the account. If you are not careful, you could actually overdraw one particular consumer's account. How would that happen? Well, you had some materials. You got a deposit from a home improvement or a home owner, put it in that trust account, and it was about $2,000. So $2,000 of the $10,000 total was to one homeowner. And you got a bill in for that homeowner's job. And it was $2,500. Well, you have $10,000 in the account, no biggie. You take $2,500 out of the account and pay for those supplies. You just overdrew that trust account. In other words, you used somebody else's money to pay for this particular job. That is a violation of the trust funds provisions. And you could get into a lot of trouble because you actually stole other people's money. And I will tell you that one of the big complaints that we get when we end up going against a home improvement contractor, and I've gone after a whole bunch of them, one of the things that we find is that the home improvement contractors that get in trouble are the ones that are using new deposits to pay to finish old jobs. They didn't get enough money from the old job, or they're waiting for money to come in on that old job and they want to get it done, so they got a new deposit in from somebody else and they use that money to work on that job. But that means now the second job is behind. And then there's not money for that. So then you got to go to the third one. And all of a sudden, it's almost like a Ponzi scheme. You're using new money to pay for old work. And all of a sudden, the contractor gets behind because there's not enough. and had to pay employees and all that stuff, and all of a sudden the house of cards falls. And it leaves all these homeowners who had given deposits stuck because they gave money to the contractor and that contractor's money had disappeared. If the contractor stays compliant with the law and keeps track of all the money and in that first job, they haven't been paid yet. They have to go to the first homeowner and say, look, I have to finish your job, but in order for me to finish the job, you're behind in making payments to me. I need the money because I can't finish your job until you pay what you were supposed to pay. Now, they can't be forced to pay more than what they were supposed to pay. That can be a whole separate problem. But you're entitled to get paid for that job, so get paid. But don't be using somebody else's money to finish that up, because then you get into violations of law. Again, the fines for just the home improvement contractor law, $2,500 per violated contract. Technical violations, $100. This is in addition to what restitution a contractor might be obligated to pay. Our office can step in and can get an injunction against the contractor, put them out of business presumably, get costs and penalties, as well as restitution, so it can get quite expensive. This is a prime area for scam artists. People need to be wary of those that are out there. I'm already hearing, it's that time of year, and I'm already hearing complaints from people who have had contractors come up to their door and say, hey, I can do this additional work for you, or I can do some work for you, and I can give you a great deal on the blacktop that's in the back of my truck, or on doing your new roof, or whatever. Not get a contract, not know who these people are. The people come and they start doing the work, and they end up charging them astronomical sums of money to have work done, and it is inferior work, and then you can never find them when they drive away. Don't fall victim to that. Some words of advice. Do not pay unreasonable advance fees. Negotiate the schedule based on completion of stages. Never get ahead of the contractor. Always be no more than equal to. So if it's 50% of the work, pay at 50% of the job, that's the best or the most that should be paid. Always stay a little bit behind so that you can then get caught up at the end. Nothing can work better for a homeowner than to get estimates up front after knowing what exactly you want done. Don't be talked into doing something. Know what job you want done in your house, know what it is, and get estimates. Best thing is get at least 3 estimates for the job that you want done. Get references. Make sure that the contractor is fully insured, meaning insuring his employees in the event that his employees get hurt. Also, make sure that they have liability insurance. That's insurance on your particular job to make sure if they do something wrong, cause damage or something, that there is an insurance policy to cover. So when a contractor says to you, oh yeah, I'm fully insured, the first thing you need to say is, for what? Are you insured in comp, for workers' compensation? Do you have liability insurance in case there's any damage done? And yeah, sure, no problem. I want to see it. Get me an insurance binder. It's very simple. All he has to do is go to his insurance agent, get an insurance binder that names you as a homeowner as an additional insured, and present you with that insurance binder. If you want to be a really good consumer, make sure you call that insurance agent and say, I have this binder issued out of your office. I want to make sure, is this binder, is this contract valid? And is my name, am I an additional insured on this policy? There's nothing wrong to ask for that. Ask for that, get it, keep a copy of it, so that if there is a problem later on, you can then fall back on the insurance policy. Don't fall for the, oh yeah, I'm fully insured. Or they gives you a piece of paper and shows you what his insurance policy is. A lot of us don't know what insurance policies are, and it could be anything. It just shows that it has his or her name on it, the contractor's name on it. You want to be named as an additional insured, and you want to know what that policy is for. Make sure he or she has workers' compensation insurance to cover employees, as well as liability insurance to cover you. Any guarantees that are being given, warranties and things like that, get them in writing. Make sure that you have those. Another thing to be wary of is, or something that you need to be aware of, if it involves a license. Now, you don't have to be licensed to be a general home improvement contractor. Certain specialties need to have licenses. Electricians, plumbers, those sorts of things. Make sure that they're licensed. Second of all, you can call the municipality and find out if they're licensed to do work in your municipality. Second of all, make sure that whatever job you're having done as a homeowner, make sure with your municipality, your building and code inspectors, of the type of work that you're having done, does it need a building permit? Don't just rely on the contractor to say, oh, no, you don't need a building permit for that. Check with your municipal code to make sure that there's no permit required. And make sure in your contract that if a permit is required, that you know who it is that's responsible for getting the permit. Put in the contract, contractor is responsible for getting the building permit. And make sure you see that permit before the work gets started. You don't want a building inspector showing up at your house, especially after the fact when all the work is done, and find out that you needed a building permit, and the only way that that permit, or the only way that that job is going to pass is you have to open up walls now because it wasn't the electric wasn't inspected, plumbing wasn't inspected ahead of time. Make sure that the permit is acquired and that whatever inspections are done before you make the final payment to the contractor. That way it can get taken care of beforehand. Check with your municipal clerk. There's been a whole host of problems where, the contractor never got the permits that they were supposed to get, and then as a result, the homeowner is that, because the homeowner is that's ultimately responsible. The homeowner is responsible to the code. The code comes out and says, hey, you aren't allowed to put that addition on your house. You know that beautiful addition you have on your house? You're not allowed to have that. And as a matter of fact, it was built in violation of the code. It was in violation of side setbacks or square footage or whatever. You have to tear it down. What? I just spent tens of thousands of dollars to do this. You've got to tear it down. Or you've got to get a variance from the code, from the zoning board or the planning board or whatever. You've got to take care of this all ahead of time. Because if a permit is obtained, you're going to know at the outset if there's been a violation. You won't get the permit. Oh, that addition is too far into the side setback requirements. You have to be 10 feet back from a side property line, and you are only 5 feet back from a property line. That's not allowable. If somebody went and got the permit and they presented to the building inspector, this is what we're proposed to do, it's at that point in time the building inspector can say, no, I'm sorry, you can't do that because you're in the side setback. Well, then you haven't spent tens of thousands of dollars building this thing. I actually had a situation where a guy did that, and he had to go after the fact to have a we refer to it in Latin, it's after the fact, nunc pro tunc, relief requesting that this variance be allowed because he built into the side setback, and they said no. What do you have to do? He had to tear it down. Avoid that. Make sure you get all the permits and everything taken care of in advance. If you, and again, one of the aspects as far as fraud goes is in the home improvement realm is, and this is true universally about frauds themselves, and that is one thing that fraudsters want to do is to get you to make decisions without the time to think about it. So when somebody shows up at your house and wants to put this driveway down right now, I'm here now, I can get this done, I'll give you a great price, run the other way. You need to have time to think about these sorts of things, and when you do, you'll be much better off, or you can make a less emotional decision. You get time to think about it, sit there, ponder it, rather than a quick decision, and all of a sudden you're regretting it after the fact. You end up getting overcharged and that sort of thing. The best thing you can do for yourself on any home improvement job, or whenever you're asked to do something immediately, is to give yourself time to think about it, especially when it involves spending money. Buying a raffle ticket. Somebody calls you on the phone and says, hey, you just won a lottery, immediately send in money to claim your prize. Give yourself time to think about it. You will go a long way toward protecting yourself. If you ever have an issue related to a business, home improvement contractor, or other type of business, feel free to contact our office, the New York State Attorney General's office. Our office is in Binghamton. We have an 800 number, which is 1-800-771-7755. You can call that number. We have staff available, consumer fraud representative available to speak with you, to answer questions that you might have. We can't give you legal advice, but we can give you some guidance. If you have a problem with a business where you would like to file a complaint with our office does mediation, so we take your complaint in writing. You can either contact our office and we'll send you a complaint form, or in this modern day and age, we have online complaint forms that you can fill out and send in that explain your situation, and we can attempt to mediate your problem with the home improvement contractor or other business, where we would send them the complaint, say we only heard one side of the story, and ask them to respond and see if we can resolve it for you in that fashion. So feel free to contact our office. It's been a pleasure being here with you today at Cornell Cooperative Extension. We invite anyone who wants to come on the second Thursday of the month at 11 a.m. to Cornell Cooperative Extension on Willow Avenue here in Ithaca to join us. It's always better when we have people in the crowd to ask questions and keep me on my toes and maybe ask something that I hadn't thought about, or worse, I had forgotten to say, and somebody asks a question that triggers that in my mind. So please feel free to come down here to our Consumer Issues program. Hopefully we will see you soon. Thank you.